Good morning. Are you Jonah Ray Johnson?
Yes, Mom.
And this is 25 DCCR 1775. Mr. Johnson is charged with aggravated assault with a deadly weapon. And Mr. Vasquez has filed a motion asking that I reduce Mr. Johnson's bond, which is currently set at $300,000 in that case. Are you calling your client?
Yes, Your Honor.
Mr. Johnson, best you can, raise your right
Oh,
hand.
no, I'm sorry, Your Honor. I'm not. I'm calling my client's mom, Jacqueline Broussard.
Ms. Broussard? Mr. Johnson, if you'll just come around just to the side, right there on the corner. Ma'am, if you'll come right over here, please. Good morning. And would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may proceed.
Thank you, Your Honor. Ms. Broussard, state your name for the record, please.
Jacqueline Broussard.
And you've done this before, haven't you?
Yes, ma'am. Oh, sir, I'm sorry.
And you are Jonna's mom, correct?
Yes.
And the original bond back in September was $150,000. Wasn't that correct?
Yes, sir.
And what went wrong? What was the problem there?
The ankle monitor. We thought it was broken, which we was led. That was, we called Johnny, and Johnny told us to come in, which we had been talking with Johnny for 2 weeks. But like I say, Johnny said come in. There's something's going on with the monitor, and we also was a payment behind.
Okay.
But we
let me interrupt.
I'm sorry. Go ahead.
That's all right. The bondsman said the defendant has failed to pay for the GPS device. It wasn't charged. He will not respond to surety's attempt to reach him. He cannot be located. Surety feels like his bond is at risk. Now, you disagree with that, right?
Yes, sir.
The bond was never at risk.
No, sir.
Jonna lives with you?
Yes, sir.
You live in Beaumont?
Yes, sir.
With your husband?
Yes, sir.
And how many people live in that house?
Me, my husband, my oldest son, and Jonah.
And how long have you been in that home?
Over 5 years.
And the four of you lived there?
Yes, sir.
Was Jonah working when all this happened?
Yes, sir.
Where was he working?
He was working for Jefferson nursing home.
Say again?
Jefferson.
What was he doing?
He was working in the kitchen.
And how long did he have that job? You recall?
I think he had just received that one over there about maybe 6 months. I'm not. Yeah. Because he just got hired out over there.
And he's 18?
Yes.
He lives with you. He's not. Is he a flight risk?
No, sir. He's not.
Are you worried about him taking off or running off?
No, sir. I'm not.
And you wouldn't waste your money if you...
No, sir. I wouldn't.
What bondsman have you talked to?
I had talked to a professional with Kenya, and I had talked also with Lisa.
Which bondsman was this back in September?
I think that was Ella.
That was Ella. Is that who you're talking to now?
Yes, one on this.
And what have your conversations been like with them?
They just ready for me to get in touch with them, see if they're not going to be reduced. I just had one text me this morning.
Have you talked to them about what amount you would want that you're trying to get reduced to? What would be reasonable?
At least 100,000. We had talked on that.
Well, it was 150,000 back then.
Yes, sir.
So it's not really realistic that that the court would drop to 100,000 now.
Mm-hmm.
Are you asking the court to reinstate I don't know if reinstate the correct word, but to go back to the $150,000?
Yes, sir. Yes, sir.
Is that something you think you could work with?
Yes, sir.
They probably want you to sign a contract for $15,000?
Yes, sir.
I think 10% is the one.
Yes, sir.
Would you make sure there was no discrepancies or mistakes or misunderstandings about the GPS monitor system?
Yes, sir.
And what else would you like to tell the judge? About the bond?
Not the one. We are ready prepared to make fun.
Have you seen the video in this case?
Yes, ma'am.
Okay.
I have talked to my son. Yes, ma'am.
You've actually seen it?
Yes, ma'am.
Okay.
The whole video.
Okay. Anything else?
Nothing else, Your Honor.
Questions of this
That was
witness?
actually one of my questions I was going to ask this witness is whether or not she's seen the video, Judge.
Okay.
In addition to that, Ms. Broussard, are you aware that your son in the last 5 years has been arrested for 9 different offenses?
Excuse me?
Are you aware that in the last 5 years your son has been arrested for 9 separate offenses?
9?
Yes, ma'am. Evading arrest as a juvenile, UUMV as an adult, possession of a controlled substance, unlawful carry of a firearm, failed to ID, possession of a controlled substance, possession of marijuana, and 2 additional unauthorized carrying of a weapon. Were you aware of those arrests?
Yes.
Okay. Now, the gun that your son allegedly carried back on August the 31st of 2025, during that shootout at the Pine Club Apartments, do you have any idea where you got that gun from?
No, sir.
Are you aware that a bystander was shot during that melee?
Yes, sir.
All right, that's all I have, Judge.
Okay. Any other questions of this witness?
No, Your Honor.
Thank you, ma'am. You can have a seat.
Thank you, ma'am.
Any other witnesses, Mr. Vasquez?
No, Your Honor.
Mr. Coleman?
Judge, one of the items of evidence that I planned on introducing was the video from the shootout. But it sounds like the court vividly remembers that. So if the court doesn't wish to see that again, I want to.
Let's just quickly play it. I want to, I'm refreshing my memory by taking, well, first of all, I'm going to take judicial notice of the court's file. I have reviewed the probable cause affidavit, which is what reminded me of the facts of the case. And I guess it was the other case that we had a bond hearing on. Is that correct?
Well, no, I take it back. It was this defendant when he was represented by Brittany Holmes, if I'm not mistaken.
So I've had a bond hearing, watched the video on this case.
Yes, Judge, if I'm not mistaken. In fact, when you look at my notes, that would have been January 13th of 2026. My notes include that there's a defense motion to reduce the bond. We argued, you heard evidence and testimony, and that you denied the motion back in January of this year.
So this was after the AFRS, and the bond was at $300,000 on that date for the same bond hearing.
Yes, Judge.
Your motion's denied. I've already heard all the evidence.
Well, there is something, Judge. I think that it's at least, if you're going to deny it, I think you may want to consider it as far as whether or not the bond is sufficient. As it states, it's just a 5-minute clip of a jail phone call that I've added subtitles to. If I could do that, I'm happy to bring my sponsored witness, but if you'll stipulate to it.
No, I'm going to object to it to relevance.
Bring your witness, please.
Yeah. State calls Captain Michael Pond.
Good morning, sir.
Morning, Chris.
Thank you for your patience this morning. If you'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. Go ahead.
Captain Ponder, would you state your full name for the record, please, sir?
My name is Captain Michael Ponzi.
And Captain Ponder, very briefly, what do you do? What are your duties at the over at the jail? That's your department.
I'm the custodian of records for the Jefferson County Correctional Facility.
And you're familiar as a custodian of record with the recording equipment there at the jail, correct?
Yes, sir.
And it's capable of making an accurate recording.
Yes, sir.
And each inmate is issued a unique identifying number, correct?
Yes, sir.
And that's one of the ways to identify who makes certain calls from the jail, correct?
Yes, sir.
Have you had an opportunity to review what I am marking? Judge, do you want me to mark this as states 2 or 3? We entered one in the first hearing back in January. I can do it 1, however you want to do it.
I mean, it's technically a new hearing.
Okay, I'll do 1. Okay.
One's fine.
All right. You recognize this USB drive?
Yes, sir.
How do you recognize it?
Because I listened to it this morning.
And are these your initials in today's date that's on this USB drive?
Yes, sir.
I'm marking it as State Exhibit number 1. You listened to it. Do you have any doubt that it's a fair and accurate copy of a jail phone call or recording of a telephone call made by this inmate from the Jefferson County Jail?
No, sir. No doubt.
All right. Judge, state off state. Statesman.
Mr. Vasquez?
How Good morning.
Yes.
How long is this video?
This is
the
an audio.
recording,
I'm sorry, the audio.
It's about a 5-minute excerpt from a 14-minute and 20 some odd second phone call.
Well, so it's been altered.
It's been clipped, yes.
Object to the alteration, Your Honor.
Judge, what's on here is the original 14-minute long video as well as the shortened 5-minute video with the subtitles added. So the original's on here.
Okay.
And by the way, I gave it to Mr. Vasquez yesterday, and he's had a chance to preview it.
States one, with both, will be admitted.
Permission to post, Judge?
Yes.
Judge, if I finish my objection?
Sure.
There's a object to the alteration, and then there's a transcription. I object to that as hearsay, where you're given
The subtitles.
the subtitles of what you think they're saying.
Do you disagree that the subtitles are correct with what you hear?
I don't know, Your Honor. I just object to it being hearsay.
Oh.
Or is it hearsay?
The subtitles are on it to what it's someone has written in what they've transcribed the conversation to be. I object to that as hearsay.
Mr. Coleman?
Judge, if the audio is not hearsay, which is a statement made by a party opponent, then the subtitles are therefore not hearsay. Judge, it's just,
Obviously, we'll be able to listen myself, and your objection's overruled. It's admitted.
permission to publish. Judge.
Yes, and that's both the excerpt as well as the entire. And thank you, Captain Ponder.
Yes.
Maybe report or monitor.
Came back in, he still ain't gave probation. The lawyer told them do probation and shit. I was actually looking at the lawyer trying to ask probation and shit. She was like, man, too much shit been going on. It's like a wild west. He told me, she was like, he got right up and he jumped him in and that little shit up. But she like, I make an example. Oh my man, crazy. People went crazy for me. Wow. All he said, people screaming that shit. They say, man, world star type of shit. Burn all over the world. All of that. A couple days later, first it was cool, we was chill. Kept like, bitch, you good, sure you good, bitch, and they good. Like, I'm good with whoop. So one day, just snapped. CO said something to him. They said, what is bitch ass want to play? So I get to the CO and they want to punch it. They go, like, 60 weeks. Whoop. Niggas are here trying to CO and trying to punch like, boom, he smacked the motherfucking computer, punched that bitch. Smacked the motherfucking computer. They come, he been in hand though. They said they can't fight. I thought he been in hand though. That bitch 25, so it was trick so good. Good. Hey, bitch. Anyway, you gotta do at least about one test. I mean, that's his taxes. If you go down and trip, he gonna put it up for college for five. Yeah. And they go miss his whole point. That's my little folks. Go ahead and push about. You want to leave your citizen to the judge? And I said, hell nah. Take my shit to trial. I said, then go out my bus for the governor. I seen all my evidence and shit. That shit bullshit, bro. let me take this child, man. They gonna drop the charge. So I took take the child. Ooh, my lawyer, now he looked at the paperwork and shit like, oh, you good? You give him time. Like, I know it's gonna take time. Because everything that's going on right now, they ain't making it no better. My shit, but like I say, they come, even if they come like this, 5-year cap, they gonna say they off probation with a 5-year cap. I take that. I want to be careful. I wanted 5 years. But if they do, I put like 2.5 on that bitch. Oh, come on, my brother. Thank you. I still bank time. Get paid. I'm gonna have some bank time. Sorry, I got 5 months bank time right now. You mean that 5 months, bitch? Man. But it was 5 months. I ain't a mother, but that shit bird, bitch. Somebody. And cause nigga been around young niggas be so hard to do, I stay out the way. But you know, push gonna come to shove, some shit gonna happen. Boom, you know. Yeah, cause like, that was my first write-up. Like, bitch, I've been chilling, so I've been quiet, doing that to nobody. That bitch just write up, got another write-up, I got fighting write-up, other fight or something. But at that time, they moved to this door. Shit. It was check out the other time. So I put me on games that know what's going on. Like, shit, so I've been saying, it was my first 10 minutes, so I was gonna carry up, boom. I said, it's coming to hell, leave, and go back. You know, there's gonna be a lot of people like this, I'm good. I'm back, man. I can't back to this, and right, something like that, man. Oh, something done, and they can get out this over. Like, the flood, you know, see it, you know. So, they ain't gonna figure the world like this, they got to do it. Good, man. And shit, say, give that nigga probation for worse shit like that. Good, this how I move. You come out on top with position probation for when you get a they just gave my other part of my free will part, they had 3 robberies. Gave nigga, ISL, fuck 3 months and 10-year probation. That's like that nigga, you can't believe. That's what I'm talking about. They gave ISL 3 months, 3 months ISL. He got 10 years probation. After he was already on probation for 10 years. But crazy, him and the dude that got us in the fight with the court the same day. You know.
That's all I have on that, Judge. State has no further witnesses.
All right. Anything else?
No, Your Honor.
Okay. So at this time, I am going to deny the motion for a bond reduction. And I guess, Mr. Coleman, depending on any future incidents, if the state wishes to file a motion to increase, I would look at that at the appropriate time.
We have contemplated that, Judge.
But Mr. Johnson, a condition still, if you make that $300,000 bond, is that you would be. Let's
in a
just quickly
courtroom,
play it.
it's
I want
not
to.
just laws being
I'm
judged.
refreshing my memory
It's
by
people's
taking.
lives
Well,
being
first of all, I'm going to
changed
take judicial
forever.
notice. The court's fine.
In this
I have
hearing,
reviewed the
we saw
probable cause affidavit,
excuses,
which is what
regret,
reminded me of the
second
facts of the
chances,
case, and I guess
and
it was the
brutal
other
reality
It was
checks
the
case
from
that
judges,
we had a bond
forced
hearing
to
on. Is
decide
that
between
correct?
Well, no, I take it
rehabilitation
back. It was this
and public
defendant when he was
safety.
represented by Brittany
Some
Holmes.
defendants were
If I'm
given
not mistaken.
another opportunity,
So
while others heard the system
I
say,
had
enough
a bond
is
hearing.
enough.
Watch the
And
video.
here's the wild part. Almost every defendant said the
case?
same thing.
Yes, Judge, if I'm
It
not
changed
mistaken.
my life.
In fact, when you look at my
But
notes,
courts don't run on promises. They run
that would have
on
been January
actions.
13th of 2026.
From probation violations and bond hearings to competency evaluations and murder allegations.
We argued,
These weren't just legal
you heard evidence
procedures.
and testimony,
These
and
were
that you denied the
life-changing
motion
moments
back in
happening in
January of
real
this year.
time. And honestly, this entire hearing leaves one massive question behind. How many
So this
chances
was
should someone get
after the
before the
AFRS,
justice system finally
and
stops believing them?
the bond was at
If you enjoy
300,000
real
on that
courtroom
date for the same
breakdowns,
bond hearing.
legal
Yes,
drama, and uncensored justice content, make sure to
I've already.
subscribe
I don't.
because
Yeah.
the next case might be
Your
even
motion's
more
denied.
shocking
I've already
than this
heard
one.
all the evidence.